Hello, everyone. Welcome to this emergency meeting of the Commoner Law Group to help folks who are being faced with vaccine mandates. And we're here to help you at this crisis moment. And so glad you made it. We have quite the interest tonight in this very poignant topic. The common law approach, I'll just say right up front, is unlike any other. It is indeed the most honorable approach and the most effective that you'll find. So again, thanks for taking out your precious time to hear about it. And my intention for you all is that you learn enough to be able to decide whether this is the approach you want to take, considering what you're being faced with at this time. So we're going to accomplish quite a few things. Definitely, we want to give you a down and dirty introduction to common law. It's very expansive because the law touches nearly every aspect of life. In the end, you'll find that it's relatively simple, but for the average person, it can be challenging because of the perspectives that you've been given for your whole life about the nature of law itself. So thanks for being here again. We're also going to give you an update on our very first success with the employees in the city and county of San Francisco. It was there that we first did our work in a political campaign. This initiative helped hundreds of San Francisco city employees manage their director of human resources, who ordered them to get vaccinated within 10 weeks of FDA approval. Well, we'd been working on that project because a couple of our students, our common law students, let us know that this was happening. And the city and county of San Francisco was one of the first governments to do this. We jumped into action because, in fact, the city and county of San Francisco also required that employees put forth their vaccination status form by the end of July. And so rather than filling out that form, we were suggesting to employees that they follow through with the common law approach instead. I'll give you an update on that. And then we're going to teach you how you can take the next steps for you. Over this last week, there's been an explosion of people trying to figure out what to do. Everyone's kind of panicking, flailing around because, well, the places you had maybe thought you would turn to in the past, for example, your unions or lawyers or even politicians, but they're not here. They're not helping. And some people want to gather in large numbers and protest and make a big stink outside of City Hall or wherever you need to do it. And that's also not going to get you anywhere. So if you thought that this medical tyranny was going to stop, or that it's going to be over soon, or that things might get better, if you've been hopeful, if you've been hoping that it's going to go away, or maybe you're going to be able to skirt through it with some clever way of, once again, going along to get along, and maybe it won't be that bad, those times are over. If you've been waiting for that time when things get so bad that maybe you'll have to do something, that time is now. And again, unfortunately, there's no one coming to save you. So I'll just throw in right away, one of the main principles of common law is that each person is unique and sovereign unto him or herself. And it's entirely your responsibility to stand up for yourself. And so what you're going to learn about tonight is a way for you as an individual to assert your rights. We're all going to be doing it at the same time, which is wonderful. You're never alone in that sense. But no one can do this for you. That's a big jump for a lot of people who tend to rely on others, particularly in the area of law. We've been taught that the legal system is so complicated, and it's true that by some estimates there are 61 million rules and ordinances and resolutions and orders and policies on the books in the United States. And that would be too much for any one person to possibly get. Even people who spend 3 years in law school and grinding it out can only come out of there with a specialization in some small area. But fortunately, the common law is, when it comes down to it, you boil down to it's very simple. You don't hurt other people. You don't go on their property if they don't ask you. You're not a menace to your community, and you honor your contracts. And these are so simple and so ancient that in a way you don't have to be told these things. And we've turned into a society where everyone are rule followers. And so we spend a lot of time talking about what rules there are and how you have to do this and have to do that. The common law is actually the law that was given to us by our creator, and it doesn't require any permission by anybody, doesn't require any man-made institutions. It's always been there. And we're very lucky that in all the years since the foundation of our country, that was indeed founded upon the principles of common law. We're so fortunate that despite the erosion of this common law to the point where it's nearly a secret to most people, there has always been a small group of people who have kept it alive. And the Commoner Law Group, in fact, is established to teach people not only the principles of common law, but the practices of common law, so that each and every one of us can regain that truth in ourselves and stand up for ourselves whenever someone should ever come to you and try to violate your natural God-given rights. So yes, indeed, the many statutes and rules and regulations that are on the books are indeed a system of laws, conventionally called laws, that has replaced the authentic common law and has flipped things upside down. Originally, people 250 years ago were taught, just when you're an adolescent, this was part of your education, part of your development. To be a good person in society, you had to understand the basics of law. And again, it's pretty simple and fundamental. And what people were taught regularly, routinely in those days, was that God created us, and so we are sovereign and free. And if we choose to, for our convenience, for our benefit as a collective, we might create governments. We might create any number of institutions to serve us. But when those governments, for any reason, stop serving us, we take them out of existence, just as we put them into existence. So the order of things is God's law, and then you, the free person, to choose how you live your life and run your family and how your schools and your community go. And then we might create governments. And unfortunately, we've got things really upside down now. So to the point where people say we have to have government. Why? To order society. If we didn't have government, what would we do? We need government to order society. And that's only true because, well, I have to give you the bad news, is that on the whole, we have become so unable to manage our own affairs, whether that's financially, emotionally, interpersonally, professionally. On the whole, we are indeed quite dependent on our government. And over the many, many years, decades, in fact, we have converted our rights into privileges. And that is, in fact, okay, because we were created free, and you are free and able to give away your rights in exchange for privileges if that's what you choose. However, when you sign up for things, many things, anything from, the list goes on and on and on, everything from driver's license to a building permit to a business license to signing your 1040 tax forms to getting employment or joining the military. You sign things and you may not realize it, but you're giving away your rights in a lot of the times in exchange for privileges, like to be able to work for the government or to be able to operate your motor vehicle. And so we've done that oftentimes out of convenience, but again, out of a need. We demand our government give us things all the time. And this is why we're in the position we're in right now, because people are afraid of a virus and they are demanding that the government do something about it and make everyone take the one and only salvation cure, which is in a needle. And that's why we're here today in this predicament. So we've got a system of laws, and a whole, who we are as a people are convinced that this is democracy, and that if everyone agrees about something, then that's the way it has to go. Forget about anybody who doesn't want to participate. Forget about people's natural freedom and their right to choose. So we've gotten into this pickle. I personally will take my personal responsibility, and I ask you to look within yourself as well and think about all the times that you compromised, or you said, well, I'll just go along with it this time, or I'll put up with this. I mean, masks in particular, how many of us have worn masks just out of convenience or to get along? How many mask mandates have you swallowed? There's always incrementalism. It's always step by step. They wouldn't just on day one say everyone has to get a vaccine today. So they entreat you and give you small steps until we get here. Now, I'm surprised personally that that's happening so fast. Seems like on cue, every government, every corporation determined this was the month that we're going to hit everybody with vaccine mandates. So fortunately, the Commoner Law Group has been training people in common law, and our experts have been training people in common law for decades. We've officially began last year because I recognized that the common law approach is really the only honorable and effective way at this time. So to give you a good example, San Francisco city employees were given a mandate, as I mentioned earlier. Personally, each person received an email from the Human Resources Director saying within 10 weeks of FDA approval, you will be required to get a vaccine. So this is a bit off down the road. And yet at the same time, they said you also have to fill out a vaccine status form within a month. So people were thinking, oh, well, I'll fill out the vaccine status form and hope, cross my fingers that day will never come that the FDA doesn't approve anything. Once again, it's hope and going along to get along and just kicking the can down the road. But we stepped in and we said, no, this is the time to draw the line. Don't even fill out that form, because by filling out that form, you actually, once again, give tacit approval and agreement to their offer to have authority over your vaccination, over what happens with you and your health. And so instead of filling out that form, we suggested to people that they follow a series of communications with this human resources director that will lawfully bind her. So I'm going to go through with you right now the exact documents that we use in San Francisco as a continued education, because once you read these documents, you're going to get them. The documents themselves are self-explanatory. They're in plain English. They make sense. You know, they aren't so crazy language. It's like you don't have to be a lawyer to understand. You'll get it right away. So conditional acceptance is a genius document. Okay, so one of the principles of common law is that we do things honorably, but we do things assertively, meaning we're not here to ask anyone for anything. Too many people today are asking their government by saying, you know, do you understand I have a religious exemption, or I have a medical exemption, or trying to teach their counter supervisor, you know, by sending them a link about the ingredients in the vaccine, or did you know that Fauci is, you know, profiting from this? All sorts of alternative facts, the facts you don't hear in the mainstream media that many of you are privy to. So people are trying to convince their lawmakers of the truth and ask them to please do the right thing. We don't ask. They are our servants. Imagine if you had somebody, you know, mowing your lawn, or pick any personal service that you might have, and that person, you know, was telling you how to live your life. It just doesn't make sense. So we don't ask. Likewise, there are a good number of folks who are pissed at their government overlords and want to really do them harm. You know, turnabout's fair play, and you've been dominating me and telling me what to do for so long. I want to show you a thing or two. That kind of aggressive attitude is also not helpful, and it's not honorable. What we do is we assert ourselves. We assert ourselves regularly, immediately, and on every occasion when someone pretends to have the authority over you. I mean, imagine. I just get crazy when I think about how anyone would presume to take the authority over my life. You know, it's beyond the pale. They've definitely crossed the line, and we are going to hold them accountable, absolutely. And where they have been criminal, we're going to make them accountable for that. That means there will be justice. But in the meantime, we're just focused on these specific mandates that are coming out all across the country, all across the world. in one form or another. So some people are getting vaccine mandates that say you have to be vaccinated immediately, no exceptions. Other people are getting vaccine mandates that say we've got a little cushion of time. And some people are offered exemptions, like medical exemptions or religious exemptions. And then other people are just being told that one day they might be required. So all of these communications are all the same in that the person who's communicating to you claims the authority over you. And so we need to correct them at every turn. So the documents that you will see just now are were specifically designed for the situation in San Francisco amongst employees because of the specific nature of the mandate as it was written. And so we're working really hard at Common Law Group. Trust me, this week, we're just sweating it out, working hours after hours, trying to get documents together that will help in every situation. So just to give you a kind of overview of what we're looking at right now, we're looking at military service members. We're looking at parents with school-aged children. We're looking at even employees who work in the private sector. They too, in big numbers, are being required. But of course, government employees are a big focus, having worked so well in San Francisco. And then as another group is just healthcare providers, because governments are not only requiring their employees, but they're extending that to include like people who work in hospitals and other healthcare settings. So those are the groups that have reached out to us in this last week saying, can you help us? Does the common law approach work in this area? Can common law help me? Is it appropriate for this situation? So we're working really hard to take these documents and create templates for all these different situations. You'll still have to customize them for your situation, and we want to support you as we go forward in getting those templates in your hands, and then working with you through all the different variations that there are out there to make sure that your documents are sound. However, the most important thing we can do is impart to you the principles and some examples, so you're in a position once again to choose whether this is the course of action that you want to pursue. So this is the conditional acceptance, and the reason it's called a conditional acceptance is because that's exactly what it is. You might be surprised. You're actually going to accept the quote unquote mandate. Because see, in common law, we recognize that none of these mandates are lawful in any way whatsoever. They're relying entirely on intimidation and the assumption that you're ignorant of the truth about who you are and your freedoms. So rather than refuse their mandates outright, which might cause a controversy where they can say, what are you refusing to do what we tell you? You don't even want to give them that opportunity. So what you say is, yes, I accept your mandate. Read this first paragraph and go ahead and just put in there whatever mandate you've seen come across your desk or your email. Could you just read that first paragraph out loud? And again, everyone, as she reads it, see if you can't get behind this. This is something that you couldn't hear yourself saying. Go ahead.
With regard to your vaccination and face covering policies dated June 23rd, 2021, and which were updated July 12th, 2021, wherein you stipulate I must submit my vaccination status and vaccination documentation to the Department of Human Resources, DHR, and must undertake medical interventions, including wearing a face covering, taking a COVID test, and or receiving a COVID-19 injection as a condition of my continued employment with the City and County of San Francisco. I conditionally accept your offer to do so upon proof of claim of the following points.
That's right. I accept your offer. It's the last thing you might have expected, right? But it is indeed a quite honorable way of when anybody approaches you, because it is indeed an offer. In fact, an offer to contract. So in case you hadn't known this, in all the 14 to 15 plus months where we've had all of these emergency orders and health orders, close your business, stay indoors, stay away from people, on and on and on. If you did any of those things, if you complied with any of those things, you became tacitly in contract with those people who told you to do that, because they have no authority over you. They just sound like they do. And then if you go along, then you go along, and it's a tacit agreement. So here we do say, I accept your offer. Right away, you're making it clear that you know it's an offer and not a demand or an obligation like they like to make it seem. And then you tell them that if you can fulfill some few conditions I've got for you, then we're good. Guess what? They're not going to be able to fulfill these conditions. So this is a place where you get to put all those things that you have been wanting to say, all these things that matter to you, all the things that you believe justify you not taking a vaccine. So the very first one, for example, upon proof of claim that these mandatory requirements are not made under threat, duress, and or coercion of potential discipline and or termination. Okay, just read one or two of these. They're called averments, but these conditions that we put together for the city and county of San Francisco employees.
Number 4, upon proof of claim that the information you and your agency, which in my case is the federal government, are basing your policies on are not erroneous, hearsay based upon mere assumption, presumptions, lies, or propaganda, and further, upon proof of claim that this country and our society is not based upon the quote rule of law, rather than arbitrary and capricious orders, rules, dictates, or mandates, which were not voted on or passed by a legislature, and further, love it, upon proof of claim that I am subject to such orders, rules, dictates, or mandates, and further, number 7, one more, upon proof of claim that any and all health mandates you promote and impress are not an unlawful attempt to impose them upon me, and further.
Very good. So how many people are already thinking, that's what I've been saying all along? So so this is a way of saying to them what you need to say to stand up for your rights in a way that is honorable. So you put it as a conditional acceptance. All right, you want to go down to the next page, please?
Number 14, upon proof of claim that you did not take the oath of office to support and uphold both the California Constitution and the Constitution for the United States of America, pursuant Article 20, Section 3, and that you are not in violation thereof, and further.
Very good. So for those of you who believe that they're not being acting constitutionally, you're right. So how do you tell that to them in a way that's honorable?
Upon proof of claim that you have not misrepresented your official title and capacity to me, and that you are not conducting yourself under color of law in violation of Title 18, Section 241, 242, and other titles affording the constitutionally secured and protected rights, and further.
Fantastic. It's one of my favorites because the color of law, they get away with so much, meaning that they pretend to have the authority. They carry a badge and they're just mocking authority.
Upon proof of claim that the vaccine manufacturers, my favorite, or pharmaceutical industry did not eliminate the possibility for double-blind placebo studies of the COVID-19 injections by vaccinating the placebo group after only a few short weeks, thus making the true long-term safety profiles of these products impossible to determine, and further. 23, upon proof of claim that you have not failed to thoroughly research the COVID-19 injections in order to determine if they have been fully tested and proven entirely safe for me.
You see, for me, remember that principle? It's person by person. And this letter goes directly to Carol Eisen, the Director of Human Resources in the City and County of San Francisco. She's personally on the hook. She's the one who's operating under the color of law. And you're saying, I accept your offer if you can prove to me that it's not going to harm me. Not that you're going to show me some study that says it's safe and effective, or you're going to quote somebody in some other agency that says it's safe and effective. You have to prove it to me that it's safe for my body, the one that you claim to want to inject. All right, great. Do you want to read another one?
Yes. 24, upon proof of claim that the statements and claims made in your email to the City and County of San Francisco employees dated June 23rd, 2021, and the new Department of Human Resources vaccination and face covering policies regarding the necessity and effectiveness of these medical products are not a violation of the Federal Trade Commission Act, 15 U.S.C. and 41, and further. Upon proof of claim that you have not failed to produce documentation and evidence showing how the Centers for Disease Control and Prevention obtained jurisdiction over me and the people of the City and County of San Francisco to dictate health procedures, and further.
Isn't that something?
Mm-hmm.
Isn't that something you've always wanted to say? How come the CDC? How come people like Dr. Fauci? Why? Who elected them? Who made them king?
And all the universities, they're clearly going against FDA and CDC.
Well, that too. Then they're arbitrary and capricious sometimes. That's right. We'll go ahead and jump to the last paragraph because there's something critical in here, and we're spending a fair amount of time on this document because it is the first one and it is pivotal. Documents that follow are all dependent on this very first document.
So upon proof of claim that mandating me is to undertake these medical interventions as condition of my employment, whether they're under an EUA designation or full FDA approval, is not a violation of my constitutionally secured and protected rights and my God-given right to bodily sovereignty, and further, upon proof of claim that you are not unwilling to accept full liability in your personal capacity for any and all financial, physical, and/or mental health problems that I might personally experience as a result of complying with these mandatory requirements.
Yeah, that was the last condition, right? It finishes
Yeah.
strong.
Okay. Your timely response within 10 days of your receipt of this conditional acceptance must be in affidavit form under your full commercial liability, rebutting each of the points of the undersigned on a point-by-point basis. The facts contained therein are true, correct, complete, and not misleading. Declarations are insufficient as declarations permit lying by omission, which no honorable draft may contain. With explicit reservation of all my inalienable and constitutionally secured and protected rights, Article 421, and any other rights, privileges, and immunities I may have with none waived and without prejudice. Very truly.
Very truly, you sign your name. And that's your name on the line here. So this is very important. You're speaking to that individual in their personal capacity from yourself as an individual person. And that's honorable. Now, you see that paragraph about how, the form in which they have to respond, because we know, and in fact, exactly what happened with the director of human resources in San Francisco. When she received this, she just simply turned around like very quickly and sent out PDF files of the exact same policy statement over again. So her response had no lawful merit. An affidavit form simply means that what you write to me has to be under oath, meaning that if you should be found to be lying, you would be perjuring yourself, and that's a criminal offense. In fact, we know that they will not respond, or that they will not respond in affidavit form. Why? Because they can't. Because they can't respond point by point in affidavit form without revealing their entire fraud. So they're going to do everything in their power to not reveal their fraud, and so they cannot really respond. We know that. That's why we have the following documents. So what happens next is we send them a courtesy notice. The courtesy notice, it sounds nice, but it's very, very important document because, again, we reassert that the response has to be in an affidavit form so that it has lawful merit. You can't simply just say, no, you really have to do what I told you. I'm going to tell you again what you have to do. You have to do what I told you to do because I'm telling you have to do it. Doesn't offer anything lawful. We tell them, okay, it's been 10 days and you've been silent, or you have, in this case, we wrote, your email but is not sufficient. And you now have 3 more days. In case you misunderstood conditional acceptance, I'm going to tell you it's got to be in affidavit form, and you've got to address each point in my conditional acceptance. We'll just let you just read a little bit. You can see, to clarify, is the beginning of the second paragraph there. And then, although I received a reply which referenced and reiterated the current policy, it was not in affidavit form, therefore it has no lawful merit. Okay, so you have 3 more days. And I guess this is the point at which I will tell you, because you might be wondering, what is this all for? Where is this all leading? So we're basically creating a paper trail, a lawfully binding paper trail, such that by the time we finish with the fourth and final document, Director Eisen of the City and County of San Francisco will have no recourse but to withdraw this policy, because if she continues, she will be criminal. And you're going to see why in a minute as we get to the final documents. But if she doesn't back out, which is definitely one high probability that we're counting on, that they're going to find a way to mitigate this or roll it back or save face in some way. But and we're in unprecedented times and can't say for sure, they might still continue to try to intimidate. And if she does, though, after the letter of Estoppel, we can go to court and we can present these documents to a judge. And we won't have to adjudicate anything about the safety and effectiveness of any particular medical treatment. We will not have to adjudicate whether she has the authority to do that, because her chance to have done any of those things is well past, having not responded to your conditional acceptance. And so a court can only rule that she is in default, in dishonor, and if in any attempt to try to push any policy on you is now a crime. So that's what we're doing here. That's why we ask or suggest that you send these documents in this particular order. So should we jump to the letter of a default now? The letter of default, it comes after that 3-day notice. You want to stay timely here and keep track of all this paperwork, keep your copies and keep your time. We're using registered mail, or you can use a professional document service. Either way, you have proof of receipt. And you use that proof of receipt date, and 3 days after you've received proof of receipt that she got your courtesy notice, you now tell her, well, you're in default.
Be it known on the blank date, I sent you a courtesy notice offering you 3 additional days to respond in affidavit form to my conditional acceptance letter dated July 15, 2021, regarding your current mandatory vaccination and face covering policies, and any and all subsequent / similar policies which attempt to infringe upon, seize, or subvert my constitutionally protected and God-given natural rights. It appears clear to me that you have no intention of providing a lawful and honorable response and have chosen to stand mute. Therefore, this notice is to inform you of the fact that you are in default due to your failure to perform a legal duty where you had a legal and moral obligation to speak. And this notice serves as prima facie evidence of your silence in this matter, pursuant to U.S. versus Prudden, 424F, and U.S. versus Tweel, 550F, 1977. A default is an omission of that which ought to be done, and more specifically, the omission or failure to perform a legal duty. The term also embraces the idea of dishonesty or an act or omission discreditable to one's profession, from Black's Law Dictionary, 4th edition. Be it further known that your lack of timely response and failure to rebut my claims in affidavit form serves as your acquiescence and tacit agreement that the factual declarations I set forth are true, correct, and not misleading and binding upon you.
And then you sign off with the same, with explicit reservation of all my unalienable and constitutionally secured and protected right. The important part to notice about this is that it said prima facie evidence of a crime. So this states very clearly, when you get to a judge, you say, look, not only did I give her notice, I gave her a courtesy notice. She didn't respond, so her silence puts her in default, and she was morally and legally obliged to respond. And so we don't need any more evidence to know. And it even says in here, it's binding upon you. It's very clear. If she doesn't respond to this, then she also tacitly agrees that this is binding upon her. So then what's the next thing to do? What would you think would be the next logical thing to do after you've done all this work to respond to the offer, to give courtesy notice, and you say, look, call the whole thing off. If you're gonna be silent, we'll just call it a day. What do you think is left to do? It's called a notice of estoppel, which simply means, in fancy words, stop.
Notice of estoppel by acquiescence. Read carefully. Dear Director Eisen, Be it known on this day, blank, that you, Carol Eisen, Director of City and County of San Francisco Department of Human Resources, by your silence in the matter concerning my conditional acceptance letter dated blank, regarding your mandatory vaccination and face covering policies in which you were given opportunity to respond in affidavit form 10 days from the receipt of said conditional acceptance, and by your silence to my courtesy notice dated blank, offering you 3 additional days and above the initial days to respond to my conditional acceptance are hereby found in default. Thus, a fraud has been committed upon me pursuant to U.S. versus Tweet 1977, therein initiating the doctrine of estoppel by acquiescence. Pursuant to Carmen versus Bowen 1906, to wit, one's silence may invoke doctrine of estoppel by acquiescence, which is now in full force and effect upon you.
Do you hear it's in full force and effect?
Be it further known that you are hereby stopped from any and all future actions, challenges, or counterclaims against me concerning this matter. Any violation of this estoppel will be construed at the very least as a torturous act against me, for which I will have a lawful claim against you. Proceeding beyond this point strips you of any immunity, real or imagined, making you personally liable to me, with the explicit reservation of all my unalienable and constitutionally secured and protected rights, and any other rights, privileges, and immunities I may have, with none waived and without prejudice, very truly in proper person's special status.
So again, the question for all of you is, can you get behind these words? We can't do this for you. We can help you understand who you are, what authority you have, and how to speak accordingly. And we've done the necessary research too into the law, precedents and case law that establishes all of these documents with, in some cases, hundreds of years of history. We can do that, but we can't make you sign these. We can't put your letter together and send it to the individual who somehow claims to have authority over your body. Only you can do that. So the question really is, can you do that? As you sit there and listen, and I really appreciate your time and attention to this, it's a different perspective than most people have on the law and where you stand in this country, who you are. Many of you even have appreciated the Constitution as a document, but even it is in the Bill of Rights is amazing that we have that. We're very lucky to have that. However, even if the Bill of Rights wasn't ever written, you still have these rights, and you still need to know that, and you still need to learn how to be that person who has rights, no matter who says so or who has written so. We're going to now start to show you what you have available to you online. This is the logical order of document delivery. I know how at first blush, this could seem really complicated. It's not that complicated. There are a few documents that we need to introduce you to, and there's some logic depending on your situation. So I would love to say one size fits all, and just give you one template for everybody. But there is a little bit of logic, and we're gonna step you through it. Don't worry. We're gonna drill down to your unique situation. But some of the high-level questions you need to ask. The first one is, does your employment contract contain clauses relevant to medical treatment? Or if you're in the military, does your enlistment document have any clauses relevant to medical treatment? Or for students, if your enrollment application had any clauses where you didn't think about it at the time, but you signed off on something. That's a very important detail that we can't overlook. So even before the conditional acceptance, we need to ask that question, okay? And we won't show you tonight, but it's just an affidavit of truth, and it's your way of revoking anything that you may have agreed to in the past that you didn't know the ramifications. You didn't know that it meant that in August of 2021 that they're going to be sticking a needle in your arm with a new genetic therapy. So again, there's an honorable way to undo contracts. Everybody makes a mistake, and it's again very lawful. It's perfectly lawful to step out of a contract if you didn't fully understand the consequences, the terms of the contract. So that's going to be a document that some of you will use, many of you won't. For everybody though, you'll go to the next question. You'll ask yourself, was this mandate you received, did it come from someone personally? Was it personally from them to you? Just like what we just read came from a woman named Carol Eisen. She lives in Berkeley. She works for the city and county of San Francisco. She's a flesh and blood human being, and she determined that she's going to write personally to every one of the 35,000 employees of the city and county of San Francisco and tell them that they have to take a vaccine. Even as I say it, it's so unbelievable. So in that case, it's appropriate to do the conditional acceptance that you just read. But many people are reporting, and this is not surprising because nobody in a city or county or federal government necessarily wants to put themselves on the line, and they may know better. They know why they shouldn't. So they publish it online and they send an email. Everyone, there's a new policy online. Check it out. You're now updated. Here's the new thing. So no one's really personally responsible. Well, you can't ignore it, and especially now, we have to address it. And good news is there are, again, lawful documents with which to do that. And we're not going to look at them tonight, but they'll be available online so that for those people who need it, you'll have these. Constructive notice is just that. On these occasions when there's just these published policies, and then everyone starts to repeat, you have to do it. Did you read the new policy? Well, you have to. Everyone has to. Didn't you know you have to? You send a constructive notice and a notice of violation. Another principle of common law is that if someone is violating your rights, you must give them notice of this violation. In honor, you have to assume that maybe they were doing it mistakenly. Maybe they didn't know it was a violation of your rights. Maybe they didn't know that you minded. So it's very much your responsibility, once again, to be assertive and tell them. So the constructive notice is a cover letter, basically, that goes along with the notice of violation where you specify the violations. And it's at this point, I like to use the analogy of if you have a noisy neighbor, right? So your neighbor's having a party, it's a little bit late, and you have an important meeting in the morning, you want to get some sleep. Because of our relationship with government nowadays, most people, the first thought is to call the police. The government's going to come in and take care of it. Well, in common law, we the people have a much more integrated relationship with each other. So in honor, you would at that point have had already developed the kind of relationship with your neighbor that you can just go knock on your neighbor's door and have that conversation directly with your neighbor, person to person, and give them notice, hey, this you didn't know it, that the volume of your music and your guests is very high level, decibel levels, and I can't sleep. That's the notice. And then you give them an opportunity to correct the notice. So you turn down the music, stop it. It's that simple. Common law is that simple. It's not foreign to you. It shouldn't be strange to you. It's ancient, and it really doesn't require, like anyone to write a regulation or a statute to tell you that. So that's all this is. We're doing a constructive notice and notice of violation. Okay, so then the last three questions are pretty standard because, again, we can predict they're not going to respond to your conditional acceptance, to your constructive notice and notice of violation. They're not going to respond, and certainly not going to respond in affidavit form. So that's why you send them the courtesy notice, as we just read, the notice of default, and the notice of estoppel. So that's the general overview. And once you've accomplished that, then you will have established a paper trail that will allow you to walk into any court if it gets that far. And your case will, in a matter of speaking, already have been adjudicated. You'll already have given the person you're writing to ample opportunity to address your conditions, to talk to you like a real human being. And if they don't, then they must be acting out of color of law. They must be in default. They must be in dishonor. And you've ordered them to stop. And if they persist, then, and it even says in there, if you persist, you give up your immunity. You're a criminal, and I can go after you in your personal capacity. And we have more. There's more to share, but I'm not going to be able to do everything tonight. There's a few more details down the road, but the question is, do you want to continue looking at things like medical? I'm going to go through the various things that I've seen people considering online, right? So one of the popular ones is, I'm going to get a medical or religious exemption. Okay, I need to tell you right out that this is not the way to stand up for yourself. When you kick the can down the road, when you succeed, whether you truly have a medical exemption or you truly have a religious exemption, and it's people are even willing to fake it in order to get through this little hoop. But when you ask for an exemption, you are asking, which implies that they have the authority to say yes or no. They have the authority over you. So if you merely fill out an application for a religious or medical or other kind of exemption, you're just digging the hole deeper for yourself. If you have already done that, don't worry, because remember that very first step in the slide I just showed you, that affidavit of truth, that to revoke contracts, you can honorably say, look, when I applied for that exemption, I didn't understand the consequences of what I was doing. I've learned since, and I'm hereby revoking. And then you go on to do those remaining documents. Okay, so I really want you to understand that's a massive choice in front of you. It's not just a minor difference. And it's also, for people who want to get a religious exemption or medical exemption, really look internally at yourself. What is your relationship with these people coming to tell you what to do with your body? Do you really want to ask them for an exemption? Do you really? Is today not the day that you finally draw the line and say, no, it's not about you offering me an exemption, to which you might decline. Many people are getting declined. When I keep saying acting honorably, because we've been trained to be rule followers, but we've also been trained to be rule breakers. That is, to try to, find sneaky ways in and around the rules. It's just not have to do the things that we don't want to do, but not really call the question. And this is a time, if ever a time in history, you'll look back on August 2021, I hope one day, and say, I stood up for myself completely and fully and once and for all. And I didn't hesitate, and I didn't equivocate, and I didn't try to find some clever way around it. And I did it with thousands of other people at the same time. And we really turned the tide on this thing because of it. No matter how many thousands of people take up this opportunity to stand in their truth and use the common law to hold these people accountable, it's only one person, you, who has to make that choice.